What's up, guys? Brian FL Law Group PLLC here with another Florida Law Weekly case update. I got 4 cases for you this week, so let's get right to it. First one is Athea versus Athea. It's out of the 3rd DCA. It's a personal goodwill business valuation case. I thought this was interesting because the Federal Trade Commission, the FTC, recently said that non-competes are going to be unenforceable going forward. So I wonder what effect that's going to have on our business valuation cases based on personal goodwill. This case was based on a 5-year non-compete. The gentleman owned a furniture store. He had a 5-year non-compete. He must have gotten a low business valuation. The wife appealed, and the business valuation was affirmed because of the non-compete. The court did reverse, however, the imputation of income to the wife because there was no analysis of the current local job market and the prevailing wages in the community, which the court has to do. They have to show what's available in the local job market for the wife in order to impute income to her. The next case was Alvares-Watters versus Watters. This is out of the 4th DCA. This is a relocation case. And I thought it was interesting because, first of all, this case took over a year from the date of the trial to the date of the final judgment. And that was reversible error in and of itself. The court took far too long to enter its final judgment. I have no idea what happened there. I think the judge ended up retiring shortly after this. Anyway, the court also reversed the school designation. This was a case where the father was up in West Palm Beach area. The mother relocated down to Parkland with the children, essentially. The children started going to school in Parkland. But the father wanted them back up there with him in the West Palm Beach area. Father had to travel to and from Parkland to pick up the children. He was spending, he said, about 4 hours a day in the car. The trial court actually ruled in favor of the father and said that the father's school designation would be the one that the children will use. But the appellate court reversed, saying it really wasn't about the best interest of the father, it's the best interest of the children. And there was really no analysis as to why the school was better for the children as opposed to better for the father to have less of a commute. So you really got to focus on what is the best interest of the children as it relates to the school designation. You have to go through the list of factors in 6113 and really do a thorough analysis of the best interest of the child. Don't just make it about, oh, this is more convenient to the father, or don't make it about, oh, the mother was being vindictive and not facilitating time sharing, that sort of thing. Really focus on the best interest of the child. Next case is Fields versus Estate of Ford. This was a probate case, but it involved child support. So basically, the mother, she acted pro se, and she was trying to get child support arrearages from the estate of the father who passed away. So this is key. If you're going to try to get child support arrearages, make sure you timely file your statement of claim in the probate court. And then if somebody objects to your statement of claim, you have 30 days to file an independent civil action against the personal representative. You have to sue the personal representative in a separate case. If you fail to timely do that within 30 days, you're not going to be able to have your claim for child support arrearages go forward. That's exactly what happened here. The pro se mother, unfortunately, she waited too long after somebody filed an objection in probate court. She waited too long and she didn't file another civil case within 30 days. So for that reason, her claim was barred, time barred. So make sure you timely file that claim in probate court. Otherwise, you might be out of luck. Last case is a paternity relocation case. This is Lane versus Fuller. It's out of the 5th DCA. And so this is key because the case got dismissed essentially because failure to plead properly. The petition, if it's based on a written job offer, you have to attach the written job offer to your petition. Otherwise, it's legally insufficient. So in the case here, the petition said, oh, we'll attach it later. We'll file the job offer later. No, not good enough. You have to attach it to the petition. Also, you have to attach and include your proposed relocation parenting plan, your time sharing schedule for the relocation. If you fail to do that, that's legally insufficient and your relocation petition will get dismissed. That's what happened here. It was error to grant relocation where the petition failed to include those key elements. Now, it was also reversible error to grant the petition here because the wife's job was based on the wife's petition was based on a relocation due to her job. But then it turns out the wife was able to work remotely So she really even didn't need to relocate. She was able to work remotely. The court said, no, you can't get a relocation just based on a job offer where you're able to work remotely. So keep that in mind, especially for nowadays. A lot of people can work remotely. Make sure you keep that in mind when you're either filing a petition to relocate or defending against a petition to relocate. That's an excellent argument to defend against it. The court also reversed the granting of the tax dependency exemption to the mother because she didn't plead for it. You don't plead for the tax dependency exemption change, you don't get it. So make sure if you're going to claim a change in the tax dependency exemption, make sure you plead for it or you will not get it. All right, that's it for this week. Hope everybody has a good one. Take care.